Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Hello, everyone, and welcome back to another episode of International Law Behind the Headlines. I'm Cal Raustiala. And for today's episode, we have as our guest, a very special guest, Monica Hakimi, who is the William Beneke Professor of Law at Columbia Law School, previously at Michigan. And Monica is currently co-editor-in-chief of the American Journal of International Law. I've asked her to come on the podcast today to talk about various issues related to the law of sieges and how sieges operate currently, historically, et cetera. And Monica is really an ideal person to have on for this. So welcome to the podcast, Monica.
Thanks so much. It's nice to be here.
Yeah, great to have you. So I thought we would start with some of the kind of fundamentals of sieges. And just to put this in context, I think most listeners are probably imagining and well aware of the debate going on around the war in Gaza and whether, and in fact, well before the war, whether Gaza was under siege in some way. This was a debated point that's maybe gone on for decades, I'm not sure, but certainly for years, and has a particular resonance now. But at the same time, there are many other examples historically and also potential examples, even contemporary ones, of sieges. So we're going to try to cover kind of the waterfront, but with a special emphasis on what's happening in Gaza today. So Monica, maybe you could just start off with a brief overview of the fundamentals of the law of sieges. How should we think about this? How does it fit into IHL? And, what's the basic concept here?
Sure. Well, very briefly, sieges are an old and accepted method of warfare, and they're basically designed to close off the enemy forces to the supplies that it needs to fight the war, so as to bring the war to a quicker end. Historically, sieges have been across the board permissible, including when they led to massive harms and up to the starvation of the civilian population. But over time, as IHL, international humanitarian law, has become more humane in its impulses, there have been some constraints that have been put on the right to conduct a siege. And these constraints, on one hand, sort of prohibit the use of siege as a method of starving the civilian population, and also prohibit the complete closing off of the seized area to humanitarian relief. I mean, just broadly speaking, and we can talk more about the specifics.
Great. So, just at a very general level, and I know we're going to get into some of the specific doctrines and concepts that run through it, but it does seem to many, and I've seen this in the popular press, for example, that sieges are a form of collective punishment and therefore should be barred or run afoul of our broader principles of human rights and individual dignity. And how do you see sieges fitting into our conception of international law in the 21st century? So this is a very broad question, but do sieges make sense given where international law is today?
Well, I think it's a great question, and they might still make sense for reasons of military efficacy. And of course, one humanitarian impulse is to bring wars to an end quickly, but they don't make sense to the extent that they impose on a civilian population unacceptable harms that we're not willing to tolerate in the 21st century in the ways that we were in the 19th century. And so there's a real tension in IHL generally between military necessity and humanitarianism. And this tension, I think, is particularly accentuated in the context of sieges, because as you say, sieges can very quickly turn into sort of methods of collective punishment, which are completely contrary to our contemporary intuitions.
Right. Okay, so let's put some detail into that and kind of hopefully make this a bit more clear what we mean. So what are some of the things you can't do today with a siege? So sieges are generally permissible. What specific acts, you don't have to exhaustively list them, but give us a sense of what some of the things are that you cannot do.
Well, the one thing that's quite clear is that a siege may not be used as a method of starvation, a method for starving the civilian population. So customary international law now provides a pretty clear prohibition on the starvation of civilians. And that prohibition also is reflected in the additional protocols to the Geneva Conventions, which were adopted in 1977. And so that's, I think, like the clearest absolute prohibition. And then on top of that, IHL imposes on the belligerents an obligation to provide for humanitarian relief to pass through to the civilian population. Now, exactly what IHL requires in terms of the provision of humanitarian relief depends on the context of the conflict, and to some extent, you might say the specific treaties to which the belligerents have become party. But in general, it's accepted that belligerents have to, at the very least, allow for humanitarian shipments to pass through to the civilian population so that their basic needs can be met.
Great. I want to come back to this issue, but just to go to something you said a moment ago about customary international law now barring starvation as a method, I presume from the way you worded that was not always the case. And so when did that evolve, or what can you tell us about the kind of trajectory of that very fundamental principle?
Yeah, it's really striking because we've seen in the development of IHL, like a complete reversal in its normative prescriptions on this front. So historically, sieges were permissible, including for reasons of starving the civilian population, so as to bring the war to an expedited end. And that was the case in the Lieber Code. It continued to be the case through until the Geneva Conventions. The Geneva Conventions do not themselves, the Geneva Conventions of 1949, do not themselves prohibit the starvation of civilians as a method of warfare. It's only in the 1977 additional protocols to the Geneva Conventions that starvation of civilians as a method of warfare is specifically prohibited. And then only in the Rome Statute of the ICC that the starvation of civilians as a method of warfare is criminalized. It's not even in the additional protocols treated as a grave breach. So it's actually relatively recent that we've had sort of the full crystallization of what we now understand to be sort of the prohibition of starvation of civilians as a method of warfare. And as it is codified in the Rome Statute, it prohibits, and this is just the language that's useful to have before us, intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, including willfully impeding relief supplies as provided for under the Geneva Conventions.
Fascinating. So was this a concerted campaign or effort to bring starvation to this level of protection, or was it more just a kind of natural evolution that over time our sensibilities changed and we began to see that this needed more explicit protection? In other words, I'm thinking of something like the International Criminal Court itself, which was the product of this longstanding, maybe at times low-level campaign, but there was a concerted effort. Is it similar in this case?
That's a really good question. I don't know the specific history behind this, or like who the main actors were who were pushing for specifically codifying this prohibition of starvation of civilians, first in the additional protocols and then in the Rome Statute. But I will say that it's very consistent with the trend we've seen in IHL more generally, which is a trend in favor of providing as many protections as are considered to be feasible, consistent with military objectives and necessities and the realities of war, to protect civilians. And so this is, if this is among, I think, the most fundamental protections of civilians, because as you said at the outset, it's a protection that essentially says, like, look, you can't, just as you can't carpet bomb the entire civilian population, neither can you starve them, which would essentially bring about the same result.
Right. So how broad is the concept of, I forget the exact phrase you just used, relief supplies, or we could we could sort of use that as a stand-in, I guess, or whatever the right term is. We're discussing starvation specifically, but it seems like it often goes beyond that in at least popular discussion, to include things like water, of course, but also possibly medical supplies, electricity, maybe internet access, maybe cell phone access. I don't know what else might be included, but those seem like some things that have come up, certainly in the context of Gaza. Do you see those all included in the same way? Can you draw distinctions? What do we know about those different categories?
Yeah, so I mean, the specific language in the additional protocols and in the Rome Statute is objects indispensable to the survival of the civilian population. And that includes, as you say, food, water. It would probably also include like medical supplies. And medical supplies, you might say, should not be excluded from an area in any event, because states, belligerents also have obligations to provide medical support to enemy combatants under the Geneva Conventions. So medical supplies, I think, are generally thought to be included in the relief material that ought to pass through a siege. Beyond that, I think it starts getting a little bit fuzzy. There's an Israeli Supreme Court decision in which the Israeli Supreme Court held that energy supplies did need to pass through into Gaza at the time of Israel's. Some would, as you say, some would call it an occupation, some wouldn't, but before the most recent round of hostilities broke out. So fuel supplies, although fuel supplies might be dual use items, and so that might raise certain questions about how to ensure that the civilian population gets enough fuel so that it can sort of continue to survive, but that fuel is not being sort of siphoned off to the enemy forces and allowing them to maintain their war machine. So things become pretty complicated when you're talking about objects other than food, water, medical supplies, the very basics that the civilian population might need to survive.
Can we drill down a little bit on the dual use issue? Because that seems really critical to a lot of this. And I suppose at a certain level of abstraction, food and water are dual use, in that an army relies on food and water as well, but we've long understood those to be distinct and typically don't treat those. But as you just noted, a lot of other things could be dual use, fuel being a very obvious one. How do we think about that in this context, that distinction? Does it even really make sense? Can we sustain that distinction?
It's really difficult. I mean, the distinction is difficult even in general under IHL, not even in the specific context of sieges. So in general, the rule is that you may target a dual use item, even if the civilian population uses that item or that object. But that general rule is one that has been subject to quite a bit of criticism, because the point is the civilian population also uses that object. And if it's heavily dependent on that object, the attack might severely affect the civilian population. Again, the issue becomes heightened in the context of a siege, where there are items on which the civilian population might very much rely, and nevertheless they're dual use items. And because they're dual use items, they get siphoned off to the combatant forces, which is exactly what a siege is designed to prevent. The other provisions within IHL that sort of help to mitigate that tension are the provisions that provide for relief consignments to pass through to the civilian population. And these provisions try to balance, on the one hand, the desire to have humanitarian relief pass through to the civilian population, and on the other hand, they permit the belligerent states to exercise some degree of control over the mechanisms and methods through which the relief consignments pass through. And so they allow, for example, a state, in this case, for example, Israel, to say, look, relief consignments have to pass through a particular checkpoint. They have to be subject to certain search procedures and so on and so forth, to make sure they have to be distributed in particular ways to make sure that they go to the civilian population. And these are ways to try to provide for the civilian population while still allowing the state to sort of establish the efficacy of its siege.
Just to clarify, I think it's clear from what you said, but it's not the duty of the, let's say, the besieging force to actually provide these goods. I want to go back to the Israeli Supreme Court case in a second, but it's not necessarily their requirement. It's that, or their duty to provide, but rather that they have to allow others to provide, or how do we think about who's doing the providing?
Yeah, it's a great question. It differs depending on the situation. So under the Fourth Geneva Convention, if the sieging state is an occupying force, and of course, remember there's a question about whether Israel is in the context of Gaza, then it has an obligation under the Fourth Geneva Convention from 1949 to ensure the food and medical supplies of the population are made available to it to the fullest extent possible, and itself to bring in necessary foodstuffs and medical stores if the resources in the occupied territory are inadequate. So if Israel is considered, as applied, if Israel is considered an occupying force, then it has an affirmative obligation to sort of provide for the civilian population in Gaza. If it's an international armed conflict or a non-international armed conflict, and Israel is not considered an occupying force, then the obligations for humanitarian relief are a little bit more modest, and there's some debate about exactly how affirmatively the sieging state has to act to provide for the humanitarian needs of the civilian population. And this is where you get into the sort of like balance between, on the one hand, saying like, well, you at the very least have to facilitate the provision of relief by, for example, doing away with any administrative hurdles that would sort of delay that relief. But that facilitation of relief and the provision of relief is also subject to your consent. And so that consent should not be arbitrarily denied, but it does give you the option of sort of trying to regulate the conditions and circumstances for the provision of relief so that you can sort of also do what you need to do for purposes of trying to suffocate the enemy armed forces, which is what you're trying to do with a siege.
Great, very helpful. So the fuller version of the duty to provide, let's say, food, water, and other essentials, doctrinally flows largely from the law of occupation, where you started in your last response. But when it's not a state of occupation, when it's sort of a normal conflict, let's say, then it's a lesser and more debated duty that might vary depending on the circumstances of the case. Is that a fair summation?
I think that is a fair summation. There have been efforts in recent years, I should just say, to try to bring, ideas from human rights law into the equation, and to say, like, look, even in a non-occupation situation, if you're in an armed conflict situation, the basic principles of human rights law require you affirmatively to provide for the civilian population. And so you should do what is possible toward that end. So that there has been an effort to, let's say, increase the burden on the sieging state to do more for the civilian population rather than less. But the basic rule, as you just articulated, strikes me as right, which is that it's clearest in the case of an occupation, and then outside of that, things get fuzzier and more debatable.
Can I ask how the law of siege and the law of occupation intersect? So I could see some people looking at that and saying, well, occupation requires, as a legal matter, that you have effective control of the territory, that you're supposed to be displacing the sovereign in a sense and providing what the sovereign would be providing in an ordinary circumstance. I'm obviously kind of glossing over a lot there. But that's the basic concept, that you're in control of the space, the physical space. And a siege isn't necessarily at odds with that, but there's a tension that you could identify between, if you're truly occupying, can you also be besieging at the same time? Because it seems like besieging requires you not to really be in control, and you're controlling the perimeter, but not the interior. Is that right? Or do they fit together well? Or how do you see the two fitting together?
No, I think that's right, actually. I'm not sure I'm not sure to what extent this question has really been exhaustively discussed or applied, because it's a pretty rare circumstance that
Right.
in which both might be at play simultaneously. But I think you're absolutely right. An occupation sort of assumes that the state has effective control in the area and has displaced the sovereign and is providing for the population in various ways, like as a substitute for the state until the occupation ends. And the siege, you're absolutely right, assumes the opposite, that the state is not in control and is trying to sort of squeeze out the enemy armed forces so that it can establish control. And so I think the tension that you identified is absolutely there.
Yeah, because it seems to go to Gaza, it seems like, there are many who have argued, as you discussed a moment ago, that Israel has long been occupying Gaza ever since the pullout in 2005 of kind of some of the settlements and some of the forces that were there. But the position has been, nonetheless, Israel has so much control of the perimeter and everything flowing in and out, et cetera, that it's effectively occupying. And if there is, in fact, a kind of true tension, then that cuts against the concerns with siege, or at least the legal argument of siege today. On the other hand, if you don't think that, which is, I think, the Israeli position, a position of many others, that Israel was not, in fact, the occupier prior to the last few months, then that flips it over. So it just has interesting kind of implications for how you see the current situation.
I think that's right. And I think probably, the way that I would think through it is to say that these stark categories of occupation or not are too stark for sort of thinking through what Israel in this case is obligated to do. That the facts on the ground, which are facts that reflect a failure of complete control, are facts that suggest that it actually might not have all of the obligations of an occupying power, and that we might not want it to have all of the obligations of an occupying power. I mean, we don't actually want, I think, Israel to be in the position of governing Gaza as if it were like a substitute governance structure for the Palestinians in any form. And so insisting on the application of all of the provisions of the law of occupation sort of pushes in the direction of insisting on Israel exerting more control than I think many think would be appropriate in this context. So I think like the sort of on-off switch of the law of occupation is not really the most helpful way of understanding it, but rather that one needs to look at the facts on the ground and sort of think about what sort of set of obligations and rights might flow from those facts. And this requires a certain like selective application. So I think it makes formal lists extremely uncomfortable, because who ultimately decides which provisions are applied and which not? And I get that discomfort, but it is, I think, more attentive to the realities on the ground and the realities of how these things play out.
Yeah, it's an interesting question. Obviously, there's a meta question about whether there's sort of, as you say, there's a formal category, you're either in or you're out, and then a bunch of things flow from it, or if we can think of it as a kind of sliding scale with various requirements flowing from certain discrete facts. That is complicated in some ways, but it's a lot more realistic, I suppose. So I don't know. That's a sort of meta question that runs across a lot of aspects of international law. But just to continue with Gaza and thinking about what is in fact the state there, or the state of play, many have pointed out that back in October, the Israeli defense minister sort of called for a complete siege, no electricity, no food, no water, no fuel, that kind of thing. Very stark language. And have looked at that and said, well, that shows that there's a siege, essentially. Is that right? Is it enough to simply call for it? Is it a factual inquiry that we have to see that, in fact, there is no electricity, no food, no water, or insufficient food and water flowing in? Can one official say it? How do we basically assess whether a siege is ongoing or not?
Yeah, it's a great question. I think we have to take the statement of the siege as, we have to take it seriously. So it's evidence in the direction of there being a complete siege and a desire and intent to starve out the civilian population. It's not the only evidence, however, and so one should also look at other evidence on the ground, the extent to which relief supplies are actually passing through to Gaza. In this case, there's quite a bit of evidence that the civilian population is in a state of starvation. And there's also quite a bit of evidence that relief supplies are not passing through at the rapid pace that one would hope to, and one would need to alleviate this condition of starvation. And so in this case, there's pretty good evidence that Israel's siege is overbearing, that it is pushing too far in the direction of starvation. To answer the question sort of more specifically than that, I think one would actually need to look at exactly the facts at any given point of time to see what is happening on the ground. But at a broad level, I think, yeah, it seems like there's quite a bit of evidence that Israel is conducting a siege in ways that is causing the starvation of the civilian population. Now, there's a separate question, and Tom Dannenbaum has actually done really excellent work on this, so I'll just refer everyone to his work. But there's a separate question of what degree of intentionality one must find on Israel's part. And so what it must be intending to do when it is conducting the siege. Is it enough just to say, well, it intends to conduct the siege with the effect of starving, and the effect of that is to create a state of starvation? Is that enough to demonstrate that it is using starvation as a method of warfare? Or must it actually intend to starve the civilian population and intend for that to be like the purpose of its siege? And Tom argues, and I think this is a persuasive argument, that the better interpretation is that an interpretation that posits that no, what is prohibited is the state of starvation, and intentionally creating conditions that lead to that state is to intentionally engage in starvation as a method of warfare. But it's contested, and I think we should recognize that there's some debate about this question, and the intentionality question becomes, of course, especially important in the context of international criminal law, where you're holding individuals criminally responsible for the intent of causing the starvation of the civilian population.
Right. That's a really important distinction you just made, because I think many people, because of the prominence of the ICC investigations and just the prominence of international criminal law today, it's easy to confuse the kind of mens rea aspects that we'll focus on in a criminal proceeding or bringing such a case with the more general question of first, this is getting away from even the question of can a state or a government have an intent, especially a coalition government like the one that we see in Israel today, where there are many different parties, and what does it mean for them to have an intent is an interesting and difficult question. But that's different than the kind of individual accountability question, which very much turns on intent. So I think it's really important that you drew that distinction. So when you look at the situation today in Gaza, so you've already stated a little bit about what you think about it and how to think about it. I'm just curious about the role of Egypt, because there is, Gaza, for those who don't have the map in front of them, is, sort of a long and skinny strip with the southern part bordering Egypt. Now, there are many factual questions about the degree of control that Egypt has over that crossing to the south and has historically had over it. But how does it come into the analysis, the fact that we have two states sort of bordering a specific place? Does that change anything? How do we think about that?
I don't think it changes the question. I mean, actually, I would say that there are three actors who are participating in the creation of these conditions in Gaza, the third, of course, being Hamas. And my view is that the wrongdoing by one of them does not absolve any other of them. I do think it's possible that all three of them are contributing to the conditions of starvation in Gaza. And the fact that others are contributing to it, that, for example, Egypt is contributing to it by closing off that point of access on its boundary, and that Hamas is contributing to it, does not mean that Israel is not also contributing to it. Or to say it further, You know,
Right.
and so I think the question illuminates the fact that it would be useful for analysts to highlight the different participants who are together helping to create this like really horrific situation on the ground. But the fact that there are multiple of them does not mean that any one of them is absolved from responsibility.
Yeah, that makes the intent question really interesting because now you're dealing with three actors that are, literally at odds in at least two of the cases, maybe in all of the cases. There's kind of very complex relationship there.
Yeah.
Yeah, sorry, go ahead.
No, I was just affirming what you said.
Yeah. And what about the ocean part? So, the other thing that's interesting is the western border essentially of Gaza is the sea. And this also makes me think of Taiwan, which is another example that has sometimes been pointed to as a potential site of a siege by the PRC, that they might blockade / siege, besiege the island of Taiwan, never setting foot on the territory, but simply surrounding it in some way, closing off the airspace, the water space, et cetera. That's certainly been done for Gaza. Historically, Gaza has not had control of entry by sea. So anything special about oceans or how we should think about that?
No, except to say that you can block off an ocean, you can block off an island in the case of Taiwan, or block off an entire shoreline in the case of Gaza, just as you can a land border. And I don't think the sort of nature of the border, whether maritime or territorial, affects the law of siege and the requirements for the provision of humanitarian relief, although it might facilitate in certain ways the provision of humanitarian relief, because if you have a maritime border that all other ships sort of have to pass through, you have a natural sort of checking point for ensuring that that passes through contains only the foodstuffs and other supplies that ought to be insured for the civilian population. So in some ways it might be easier, although it requires more human power because it requires a lot larger, it might require a larger force. But it also provides a checkpoint for allowing for the provision of humanitarian relief.
Yeah, good point. Well, this has been a really excellent discussion and really interesting and obviously a very important topic. Anything you want to leave us with that we should think about as we think about questions of sieges generally, IHL, Gaza specifically? Any sort of final thoughts or things that you're kind of puzzling over?
Yeah, I mean, I guess the one thing I would say is as I indicated earlier, we've seen in the development of IHL a push toward, I think, what are reasonably described as like the humanitarian impulses of international law in the past 50-ish years. And I'm quite concerned, and I think that's wonderful from the perspective of like saving humanity in awful times of war. I'm really quite concerned that the balance between the humanitarian impulses and what states are willing to do for reasons of military necessity is shifting, and we're beginning to see a regression. And I think we're beginning to see a regression because states are increasingly looking to take territory. States and other political entities are increasingly looking to take territory. Ingrid Brunk and I are working on a project on territorial conflicts in international law. We suspect that they're on the rise. We think Ukraine, Taiwan,
Yes.
Gaza, what Iran is doing in other parts of the Middle East, these all reflect Russia and other parts of Eastern Europe, China and the South China Sea. These all reflect a sort of an increased appetite for territory. And territorial conflicts have proven historically to be among the most brutal and difficult to resolve, especially when they invoke historical claims of origin, as many of them now are. And in these kinds of conflicts where states or other entities understand like their entire existence in some sense to be at risk because their existence is contingent on territory, I think we're likely to see less willingness to go along with the completely appropriate humanitarian impulses in this area. And so I just really am quite worried that we're going to see a regression, even as there are some efforts to push more toward the humanitarian impulses. I think on the ground, we're going to see much more of a regression. And I'm not sure what the sort of points of confluence will be to try to bring the humanitarian with the sort of desire to fight back into some balance that gives the humanitarian the weight it deserves.
Well, that is a really important and difficult issue that you raised. So I appreciate you saying that, and very much appreciate you coming on, Monica. This was an excellent discussion. I hope we can have you back on this or another topic sometime soon.
Thanks, Cal. It's been really nice talking to you.
Great. Take care.